The order following hearing on status of minor guardianship. Hi, I'm Darren Findling of the Probate Pro, and we're going to cover this particular court order. It is SCAO form PC 656. SCAO stands for State Court Administrative Office PC Probate Court Form 656. It was revised in August of 2024. It's important that you use this document and not any of the earlier forms, or the court may reject it. If you notice at the bottom of this particular form, you'll see the date of revision, the form number, and of course, the relevant statutes and court rules that apply to the use of this form. As it's stated at the top of this form, it is only used in a minor guardianship. It's following a hearing, a status hearing on a minor guardianship. So please don't use it for an adult guardianship or conservatorship or for any other purpose other than the stated purpose of a minor guardianship. Let's work our way through the form. Top left corner is the county of the court. Top right corner is the case number or file number and the name of the judge. As we work our way further down, there's a spot for you to identify the address of the court as well as in the matter of. In the matter of would be the name of the minor upon which this guardianship exists. In addition, under paragraph 1, it states that notice of hearing was given to or waived by the interested parties. The reason that is stated is that this is an order. This would have been after the court hearing, and for there to have been a court hearing, there would have had to have been notice given by mail or other means, as well as or a waiver from the interested parties. The second paragraph says that following a hearing on the status of the guardianship, the court makes the following findings of fact. Here are the findings of facts. The court gives you spots to click off the various boxes depending on the circumstances. In paragraph 3, it says it is in the welfare that the guardianship either be terminated or continued. Pretty intuitive there. Paragraph 4 provides that if there's an attorney or lawyer guardian ad litem that should be appointed to represent the minor, or the matter should be referred to the Michigan Department of Health and Human Services for further investigation. This is allowing the judge to either appoint an attorney or a lawyer guardian ad litem or a referral to the Michigan Department of Health and Human Services. In the order section, again, a lot of check boxes, some flexibility on the use of this document depending on the circumstances. Paragraph 5 provides that in the event of a limited guardianship, you can click that box and then it says an annual review shall be held on. And if the court has identified that there's going to be an annual review, it would go there. And if there's any modification to the limited guardianship plan, it would go in that section. In paragraph 6, it provides for a full guardianship. If the full guardianship is going to be continued, as well as whether there's an annual review, and if there are any structured or court-structured plans that have been put in place for the parents or guardians or the child that they have to abide by. And there's a few lines there, but of course, the court can attach additional language if there's insufficient space there. Paragraph 7 provides in the event that the guardianship is terminated, the letters of guardianship canceled, and the guardian being discharged. As we work our way onto the back side of this document, there's a space for the case number. In paragraph 8, it says the guardian shall terminate within 6 months of the court order as follows. And it gives an opportunity for the date for the return of that child, as well as a reintegration of the home of the parents, a reintegration plan. This would be in the circumstance that the guardianship is terminating and they're being reintegrated into the home of the parents. Paragraph 9 provides for a spot if the Michigan Department of Health and Human Services are going to be involved for supervision of that transition plan, and provides for an opportunity for the description of the services that would be provided. Paragraph 10 provides that the guardianship is continued until further order of the court for a period not exceeding 1 year, because there's a rhythm of 1 year for a review. And there's a space for if the court is ordering the parents to comply with the existing limited guardianship placement plan, a court-modified guardianship placement plan, or a court-structured plan. Again, a lot of flexibility in the use of this form, as well as a spot in paragraph B for a review hearing. In paragraph 11, it then again provides for the Michigan Department of Health and Human Services to allow their involvement for an investigation, as well as the appointment of an attorney or lawyer, guardian ad litem, and then again for review date. So you can see this form gives a lot of flexibility for the court depending on the set of circumstances that occur. And then at the bottom, of course, a spot for the judge's signature. At the Probate Pro, we are passionate about everything probate. If you have a question about this order following the hearing on the status of a minor guardianship or any probate or trust related issue, visit us at theprobatepro.com or call us at 833-PROBATE.